Welcome into Mock Trial Masterclass, your guide to controlling the courtroom. I'm Luke and I want you to be a mock trial master. Let's talk about how you can make that happen. In the mock trial world, one of the most important things for you to get right as an attorney is objections. If you get them wrong, it can really derail your performance and make your score hit the toilet bowl. But if you're strong with your objections, if you're confident with your objections, your score will go through the roof. Now, getting to that point takes a lot of time. It takes studying the rules of evidence. It takes studying the process for making and arguing objections well. And it takes doing that for a little while. But the starting point for getting great with objections is understanding the basics of the major types of objections. In the mock trial world, there are 6 objections you're going to see more often than any of the others. And what we're going to do in this video is break down the basics of each of those 6 types of objections. Now, one video isn't enough time to do a deep dive on 6 different types of objections, but this is going to let you know the fundamentals. It's going to give you a framework so that you can move beyond this video and dig in deeper and learn more about each of those rules. So if you'll promise me that you're not just going to stop here and think that that's going to get you where you want to go, but rather that you use this as a foundation, as a basis for harder and deeper work down the road, I'm ready to hop in and talk about the 6 most common types of objections in mock trial. Ready to hop in? Let's do it. First objection we're going to talk about, and these are in no particular order, is relevance. Now, relevance is one of the words on this list that I probably don't need to teach you the legal definition for you to have a concept of what this word means. Relevant is a word that we use in our everyday conversation. You might be talking to someone about politics, for example, and they bring up a particular point, and you say, yes, but that's irrelevant. That's not relevant to what we're talking about. Well, you kind of made a relevance objection when you're doing that. Because that word relevance, simply put, means, does it have to do with what we're talking about? Now, there are legal terms and legal words that are going to more specifically, in a more detailed way, break down what relevance means in a courtroom. But as you're starting out and getting familiar with these types of objections, that's what you need to understand, most of all with relevance, is it's dealing with exactly what you know relevance to be. Does what we're talking about right now, does what this witness is talking about right now, do the questions that this attorney is asking actually have anything to do with this case? Are they actually helping this case move in one direction or another? For a deeper dive on relevance, you can click the link in the description for my video all about it that's going to lay out everything you need to know about relevance. Number 2 on our list of most common objections in mock trial is hearsay. Now, those 3 letters at the end of the word hearsay that spell out say are really important when understanding this rule, because hearsay is dealing with things people say or have said. Either things that someone has spoken out loud, like I'm doing to you right now, or things that people have written down. Either one can be hearsay. Now, the hearsay rule, as you dive into it and start to understand it more, you'll learn that it doesn't completely exclude anything that anyone has ever said outside of a courtroom before. There are some nuances to it in some ways that you can get statements, whether spoken or written, into the record in a court case. But generally speaking, within a trial, we don't want to rely on things that people said. Because think about it. I'm on the witness stand. I'm being asked questions about maybe something I really don't know a whole lot about. And I say, well, you know what? I don't know about this, but I heard from Jim over there, and Jim said that defendant over there, that he's bad news. Now, I've never met him, but that's what Jim said. Do we want that type of evidence to enter a trial? Absolutely not. Because who we really need to be talking to in that situation is whoever I heard that thing from, right? That's why, generally speaking, we don't want to bring things other people have said into the courtroom. For a complete breakdown of the hearsay rule, as well as the nuances I was hinting at earlier, and some of the situations where things someone said or wrote down earlier are allowed in a trial, you can click the link in the description for a deeper dive. Number 3 is what we would call simply Rule 403. Now, this one is tied to relevance because when you're making a Rule 403 objection in court, you're dealing with evidence that both sides are going to, for the most part, agree is relevant. In other words, evidence that has something to do with the case. The problem is sometimes evidence, even though it's relevant, even though it has to do with what we're talking about, It has another problem in that it might affect the jury in an unfair way. For example, let's think of a murder trial. Do we think it would be okay for me to show the jury pictures of a bloody, dead, maimed body that are just going to get them really angry and kind of inflame their emotions so that instead of actually thinking about the facts of the case, they're just really mad and they're going to convict whoever the defendant is based on that? No, that wouldn't be fair. What situations like that Rule 403 prevent from happening? Situations specifically, as the rule would say, where the danger of unfair prejudice, situations like the one I was just talking about, substantially outweighs the probative value. In other words, how useful the evidence is. Now, I know that's a lot, so like all the other rules on this list, I've got a link in the description for a deeper dive on Rule 403 that's going to really help you understand it. But from a basic standpoint, that's what this rule is all about. All right, we're flying through the list. Number 4, improper character evidence. In a basic sense, improper character evidence is when you use someone's character, whether that's a character trait of theirs or something specifically that they did in the past to demonstrate their character, and you use that in a trial in an effort to prove that they'd be more likely to do something similar in the future. That's why this is sometimes called propensity evidence. You're taking someone's character to prove that they have a propensity to act in that way. The reason we don't want that type of evidence used in trials, whether a real trial or a mock trial, is that evidence like that just isn't very reliable. Because think about it for a second. When you're dealing with someone's character, can't someone's character change over time? I mean, when I was in high school, like all I ate was pizza and chicken nuggets. And while some people still tell me I have the diet of a 4th grader, I can promise you it's a lot better now than it was back then. So, if I was on trial for my diet, if we want to use a really silly example, I wouldn't want someone using the character I had back in high school to prove that now I would have the same diet, that I would have a propensity to eat that way, because I don't eat that way anymore. I eat a lot better now than I did back then. And that's why we don't want this rule to come in, because people can change and it's just not very reliable evidence. I've got a deeper dive on improper character evidence, a link to that in the description if you want to learn even more. Number 5 is improper opinion. Witnesses can't just get up on the witness stand and start giving their opinions about the case. I think so-and-so is guilty. I think that this company actually did make a product that was faulty. Now, the exception to that is when you're dealing with an expert witness who has been certified or built up as an expert under Rule 702 of the Rules of Evidence. But generally speaking, witnesses who aren't experts can't give their opinion unless it's a really basic one that's simply based on something they perceived. I can give an opinion that it felt hot outside on a particular day. I can give an opinion that someone looked angry based on the fact that their face was red and they had a clenched fist and were kind of jumping up and down, right? Those are things I'm perceiving. Those are really less of opinions. But in terms of specific opinions that might require expertise, some kind of specialized knowledge or anything like that, that's going to be out of bounds for anyone who's not an expert witness, which is why you'll hear an objection a lot of times to improper opinion or improper lay opinion. That's exactly what that's talking about. Before we get into the 6th type of objection, I want to make sure you know that my book, Mock Trial Masterclass, is available on Amazon. If you're new to this whole mock trial thing, or even if you're a vet, this book is full of tips to help you take your performance to the next level. For beginners, it's full of explanations of what each of the parts of mock trial are all about, how to get good at them, how to do them well. And for veterans, it's full of tips and advice that you might look at and go, I've never thought about doing that before. And these are all things that I've just learned over my 10 years of competing in and coaching mock trial that to me were all unknown at one point, but now they're all in one place for you to get, for you to grab onto. And you can pick up your copy by clicking the link in the description on YouTube or in the show notes on podcast platforms. All right, objection number 6 that you're going to see a lot of times in mock trial is either speculation or lack of personal knowledge. And this is another objection that you can probably understand just based on your existing knowledge base. Because you don't need me to explain to you what it means for someone to be speculating or to be talking about something that they lack personal knowledge of. Because speculating is when I'm talking about something that I don't know for sure. Maybe I'm talking about what I think someone had on their mind at a particular time. I'm maybe making some future prediction that may be true but also may not be true. It's things that I don't know for sure. And then if I'm talking about something where I have a lack of personal knowledge, I'm talking about things that I don't know at all. I may just be making it up. I may be going based on a hunch, but there's no real personal knowledge in that situation. It's not anything that I know at all. And that's what these two rules, that's what these two objections are dealing with. You can get a deeper dive by clicking a link in the description, but from a basic fundamental standpoint, that's really all these rules amount to. What I hope that this video has done for you, more than anything else, is help you realize that these rules of evidence aren't quite as complicated as they seem. If you look at the rules as they're actually written in the federal rules of evidence or in your state's particular set of the rules of evidence, it can seem really complicated. There's a lot of legalese, but when you break them down, they're not nearly as difficult. Now, again, like I said in the beginning, you got to take a deeper dive. You got to read the rules and understand what they're all about. But that's why I've linked these deep dive videos in the description. And if you pick up a copy of my book, you're going to find the exact same thing there. There's a whole chapter in the book. It's the longest chapter in the book that breaks all of these down a lot more detailed than what we were able to do in this video. So I hope this is a good starting point for you. I hope this gets you excited about diving deeper and learning more about the world of objections, because once you can master objections, the rest of this stuff just kind of comes with it. So go do it, go put in the work, and I know that if you do, your objections will rise to the level of a mock trial master.